Good afternoon or good morning, depending on where you are joining us from today. My name is Heidi Friedman, and I am a partner in Thompson Hine's Environmental Practice Group. I'd like to welcome you to today's webinar. This is the sixth in a series of webinars targeted at issues that businesses face operating in a COVID-19 world. Our next scheduled webinar is June 16th, and it's a tongue twister, but it's titled Product Pricing Pitfalls During a Pandemic. From sweepstakes and contests to discounting, price discrimination, and price gouging. I had to say that 5 times fast. We are planning additional webinars as topics arise. To sign up for those webinars or any others, please visit our COVID-19 task force page. So before we begin, just a few of the housekeeping items. Today's program is being recorded, and we will send a link automatically to all attendees within 48 hours of today's presentation. If you have any questions at all during the webinar, feel free to use the question box located in the control panel on the right-hand side of your screen to submit questions. We will answer as many of the questions as we can at the end of the webinar, and we have saved time to do so and would definitely encourage you to ask questions. We will be offering CLE credit for today's webinar for the lawyers on the phone. Please be sure to fill out and return the webinar affirmation form that can be found in the handout section of the control panel, also located on the right-hand side of your screen. The form provides instructions as to where to send the completed form. You'll need a tracking code, which I will announce at the end of the program, so stay tuned for that. In the handout panel, you can also download a copy of the PowerPoint slides and a bios of today's speakers. Again, we thank you very much for your time and for your interest. And if you have questions as we go along, please do use the question box. So I'm delighted to introduce my Thompson Hine colleagues that will be presenting with me today. Joining me are Devin A, a partner in our Thompson Hine's environmental practice, Joel Eagle, also a partner in Thompson Hine's environmental practice, and Tasha Miracle, an associate in Thompson Hine's environmental practice as well. I'm going to pass the baton to Tasha now to start the presentation. Tasha.
Thanks, Heidi. Hi, everyone. I'm Tasha Miracle, and I'm going to get things started today by giving you a brief overview of US EPA and the state's various COVID-19 environmental enforcement policies, or as we like to think of them as the enforcement discretion policies. So the first thing I'm going to talk about today and sort of set the stage with for us is this timeline. I'm not going to go through each of these events. I don't think that I need to remind all of you how quickly all of this happened, but I do think it is important to sort of use this as a frame of reference for what we're talking about. And that just is very generally that, all of this stuff hit the fan in the middle of March. Very quickly, you saw stay-at-home orders and some environmental enforcement policies from the states. It's not until late March that you see some sort of nationwide policies from US EPA. And then very quickly by April and May, you start to see actual legal challenges to US EPA's policies. So the first policy we're going to talk about is that nationwide US EPA policy that came out in late March. And that is US EPA's enforcement discretion policy for short. You can see the longhand title is right here. And that policy, again, came out March 26th, but it retroactively applies to March 13th, and it remains in effect until 7 days after EPA issues a termination notice. I checked this morning, and that termination notice has not been issued, so this guidance document is still in effect. And what this guidance document does is essentially lays out the steps that US EPA wants a regulated entity to take if they are foreseeing any potential non-compliance. And it has very specific steps that those regulated entities should take. And I'm not going to go through all of those steps. You're going to hear from Joel Eagle about those a little bit more later in his section, but those steps are laid out in the policy. And if any of you are familiar with administrative orders that US EPA issues, the steps sort of very similarly align with a force majeure clause that you might see in one of those AOC agreements. And again, if you are seeking that type of enforcement discretion, you have to follow the steps. It's not automatic. You have to be able to demonstrate that you are entitled to it. And at that point, it's just US EPA's discretion whether they agree that you are entitled to some type of of flexibility here. And there are, I should note that there are certain non-compliance events that would require affirmative reporting. You can't just rely on the steps in the guidance document. And some examples of those events are any potential non-compliance with an NPDES permit or potential non-compliance with a Clean Air Act permit. Anything like that, you have to tell US EPA affirmatively that you suspect that that's going to happen. So I pulled these quotes out of US EPA's enforcement discretion policy just to sort of emphasize that this policy from EPA is not a get out of jail free card, and that US EPA still expects all regulated entities to continue to comply with their environmental requirements. Despite that reassuring language in the guidance document, you saw some pretty quick reactions to this policy document from US EPA, and I pulled just a few quotes here, but there are certainly more than this. And you see from President Obama's former EPA chief, she called it an open license to pollute. Other former EPA officials say that it's essentially a nationwide waiver, and then some news stories with inflammatory language saying that EPA stopped enforcing environmental laws entirely. And that goes on for a couple days, and then US EPA pretty quickly on March 30th issues this press release, which you can see a snip of it here, and basically says, did any of you actually read the policy? And sort of reiterates that it's not a nationwide stay of enforcement compliance requirements. It is just a policy to help people demonstrate and document why they might struggle with compliance. US EPA's press release, perhaps not surprising to you all, did not allay the fears of environmental groups and Democratic-led states. So shortly after US EPA issued their press release, environmental groups led by the NRDC, the National Resources Defense Council, submitted a petition to US EPA for an emergency rulemaking. And that emergency rulemaking would essentially require any entity facing an instance of noncompliance to affirmatively report that noncompliance within 7 days. And it's not hard to see here what those environmental groups wanted. They, want to be able to track each and every single entity that may have faced noncompliance with any federal requirement. And after those environmental groups filed their petition for emergency rulemaking, US EPA actually sent a letter on April 2nd. It's not featured here, but they sent a letter on April 2nd to the Senate, sort of reaffirming this is not a get out of jail free card, and that people still have to comply with environmental requirements. That letter was not sufficient for the environmental groups. So on April 16th, they filed a federal action in the Southern District of New York, and you can see sort of a snip of the front page of that complaint here. Challenging US EPA's failure to respond to the petition for the emergency rule, and basically saying that US EPA does need to respond and needs to issue that rule. They very quickly thereafter filed a motion for summary judgment, asking for US EPA to act on the rule. Shortly after that, on May 29th, US EPA filed a cross motion for summary judgment, saying that essentially that this lawsuit should be dismissed and that US EPA is still assessing the petition for the emergency rulemaking and will issue a formal response, but that, the response they believe that the environmental groups want would violate notice and comment and the notice and comment rules for a variety of environmental statutes, and reiterating sort of more fully why US EPA issued the policy that it did. US EPA, hits on the fact that it oversees over 1.1 million facilities in the country, and it's just not feasible for US EPA to ask every single entity to affirmatively request some type of discretion. And they also emphasize that, most states have primary authority or jurisdiction over federal environmental requirements in those states. And so really it is the states that are on the front lines here, and this policy is not as egregious as the environmental groups are claiming. And the environmental groups filed a response to that motion on June 5th, and then US EPA's reply is due on June 12th. So mostly experts acknowledge that the environmental groups have an uphill battle here on this challenge, but certainly one that is worth paying close attention to for the potential impact it could have on a rulemaking like that. And then the last challenge I want to talk about is the previous slide, please. Thank you. is the challenge filed by 9 Democratic-led states. And they actually challenged the policy itself. And this was filed by New York in the lead and was filed in the same court in front of the same judge actually as the prior litigation. And I previously had to report that nothing had happened on this litigation, but I checked this morning and that has changed. Just yesterday, these states filed a motion for a preliminary injunction asking that the federal court issue a nationwide stay of the environmental enforcement discretion policy. So again, that was just filed yesterday, no response yet, but they are asking that US EPA's policy be stopped across the board. So if you I would pay close attention to that, and particularly if you are operating in any of the 9 states that filed this challenge, and I'll list those for you here in a second, I think that it would behoove you to pay close attention to what those states are doing, because they've certainly shown their hand here that they are not going to accept any type of noncompliance leniently. And those 9 states are New York, again, the lead, California, Illinois, Maryland, Oregon, Michigan, Minnesota, Vermont, and Virginia. So moving on to another guidance document, US EPA in April issued a guidance document that applies to site field work, specifically on CERCLA, RCRA remediations, in addition to TSCA PCB cleanups, UST cleanups or underground storage tanks, and also any Oil Pollution Act cleanups. And this policy was actually issued to the regions and sort of lays out, again, the factors that US EPA regions will consider if you need to delay or defer work at an individual site. And the key factors that US EPA talks about are considering what orders may be in place in those local jurisdictions, and also, of course, considering what impact any deferment or delay may have on human health and the environment. Next slide, please. And here I've just listed a few other US EPA enforcement discretion policies. I would encourage you to take a look at US EPA's website if any of these might impact your operations. US EPA does have a pretty thorough COVID-19 enforcement and compliance website with additional guidance if you need more information on these policies. Next thing I want to talk about is DOJ's memoranda that halted the collection of civil debts and halted new enforcement actions. DOJ issued that on March 31st, and then pretty quickly on April 13th issued a clarifying memo stating that DOJ could still collect penalties on voluntary settlement agreements and still could use the law to collect any late payments. And those guidance documents actually ended on May 31st, and I checked this morning, DOJ has not extended them. But I think that based on the tenor and sort of the tone of these memoranda, and the fact that the second one sort of instructs the U.S. Attorney's offices to, in individual cases, consider potential financial respite to parties that have been impacted by COVID-19, I think that type of language indicates that DOJ, the individual DOJ offices, may be willing to accept those types of arguments, and you could reach out to them and attempt to let them know about your hardship. And the last thing I'm going to talk about very briefly are some of the state's enforcement discretion or regulatory flexibility policies. As I said at the beginning, many states issued policies before US EPA did. Some issued policies after US EPA, sort of following their lead. Some of those policies are more stringent than US EPA's and require affirmative reporting. And then several states didn't issue any enforcement discretion policy. So states really did go their own way. And this is just a brief overview of a few states' policies. You can see that Ohio, Michigan, and PA all set up an email address where you could affirmatively report and request some type of discretion. I know that in Ohio EPA, it was initially just an email, and then they eventually created a form that they wanted all entities requesting some type of discretion to fill out so that those could be more uniform. And then states like New Jersey issued a number of guidance documents, and then states like New York and Alabama did not issue any policies. And New York, as you can see, and I've alluded to earlier, has harshly criticized EPA's policy and asked for it to be rescinded. So if you need additional information about any particular state's enforcement discretion policies, I would encourage you to take a look at Thompson Hine's 50-state guide. I cannot take credit for working on this. I did not, but several excellent attorneys in Thompson Hine's Environmental Practice Group did. And I put a few snips here just so you can see it is very user-friendly. You click on a state in a table of contents, and it takes you to a little chart summarizing each state's policies and linking to those policies. So if you need additional information, I would definitely encourage you to check that out. I know that it is updated regularly, although I can't say when the last time it was, but it is updated regularly. So with that, I will hand it back to Heidi.
Thanks, Tasha. So my goal is really to highlight the trends in environmental enforcement that we've seen in the last few years, with a real focus on the past few months since COVID-19 hit. So I really want to let you know sort of how our company's actually responding, and most importantly, what we have seen from the agencies on the federal and state level. So first, I just want to lay the foundation for you. So it has been a shift from enforcement, from compliance to enforcement for several years now, where EPA even renamed its national enforcement initiative. It became from what it used to be the compliance initiative to its national enforcement initiative. And there's been investigations of the decline in enforcement. There has been, significant cuts, as we all know, in EPA's budget, both for this fiscal year as well as significant cuts even to the Superfund program projected for 2021 if those are finalized. And even if you take a look with these budget cuts in mind at EPA's most recent enforcement report for 2019, which comes out in January 2020, and it always comes out in January of the following year, it really focuses on the primary underlying theme you can see is there are a number of smaller number of cases with the largest potential liability. So the biggest and the baddest in their mind. Go ahead, Joel, if you want to go to the next slide. So I did want to say, though, that even though this has not been, this has been extended even more extensively over the last couple of years in this administration, the decrease in enforcement has really been something we have seen for several different administrations. And this is the, I think, second page of US EPA Office of Inspector General report that came out a couple of months ago. And this shows, decrease in enforcement actions ranging from 33% to 48%, depending on what area you're looking at between 2007 and 2018. And the report dives into all of this, but I think it is a pretty dramatic picture to take a look at, and that this is not something that's just this administration, but certainly something that's been happening over time. This slide actually comes out of that January 2020 EPA enforcement report that I just mentioned for enforcement in 2019. There's a ton of fabulous data and graphs in that report if you are interested in them, and it shows everything from how much sediment has been removed from Superfund sites to how many criminals enforcement actions have been prosecuted, et cetera. But this slide relates to the number of inspections, and I wanted to call it out because I'm going to talk a little bit more about inspections in a few minutes. And as you can see, there's been a pretty significant decrease in inspections over time. Keep in mind, though, that a lot of the inspections, as Tasha sort of mentioned, happen at the state level. So, we're also, it's really important to consider the state inspections as well, and we're going to talk about that. So on top of this foundation of decreased enforcement, we now have a May 2020 executive order out of the White House that basically says, so in situations where agencies need to prioritize the economy, they should really exercise discretion when folks are making a reasonable good faith attempt to comply. So I've had lots of conversations over the past couple of weeks with agency officials in various regions. And so far, I will tell you that they're not even having conversations about this. So I don't have any great insight. No one really understands or knows what it's going to mean, or if it's really going to mean anything. One could certainly imply that a violation might have to be willful if you are going to take this policy to heart. But it does emphasize good faith compliance, which is a theme we also see in the COVID policies that Tasha referenced. So I think that that is probably a little bit meaningful. So what I really want to focus on is what have companies actually been doing? So our company is actually going ahead and using the US EPA COVID-19 policies. So let's talk about on-site work. So basically circle and RCRA sites. So the short answer is absolutely yes. So we have probably put in about 10 requests over the past 3 months, let's say, and mostly at the federal level, some at the state level, and mostly for on-site work. And most of our requests have been to suspend or delay. And the assessment is based on a variety of factors. Tasha referenced it generally, and I think Joel will talk about some of them more specifically. But we look at all these things in this box here, and with a big focus on the documents that's guiding the situation, whatever order it is, and enforce majeure clauses. I'm sure none of us thought when we started 2020 that we'd been spending so much time using the word force majeure or trying to figure out what it means. But what I can tell you is that we have been putting those requests in, sometimes using the force majeure clause and sometimes not. And they have been very routinely granted. And I'll talk in a minute a little bit more about how the agency has actually analyzed those requests. And what's really important is the expectation is from both the federal and state level is that you're constantly reevaluating. So even though maybe we weren't able to go out in April and we were feeling that we, based on the CDC guidance then, because of travel and restrictions and stay-at-home orders, we couldn't get consultants in the field safely to do certain work. That is, the expectation is that may be different in June, and that you need to continue to reevaluate, and you need to make the determination whether or not to now go forward with your missed event or missed implementation of construction or whatever it may be, and that it's not just an ongoing delay. And what is really important as well is to make sure that you stay in communication with the agency. And even though the US EPA policy did not specifically say you had to provide notice for these type of things, Tasha mentioned things you do need to provide notice. We certainly use it as a best practice to always notify the agency. What we haven't done a lot of, and the agency I know in talking to the folks in different regions has not seen a lot of, is use of the policy at the facility level for issues with permit compliance, whether it be related to record keeping or testing or those kinds of things. And they've seen no request to exceed any permit limits, at least from the folks that I talked to so far. And part of this, of course, may be due to the fact that a lot of companies closed down their facilities, and in starting them back up, there just may not have been an ability to do that reporting. And we may be seeing a little bit of catch up here. Next slide, Jill. Thanks. So how has the agency responded? So in all of the 10 or so requests that we have put in, we saw the exact same language coming back, whether it was out of Region 5 or 4 or 3 or 9 or Ohio or Virginia or wherever. We always saw the term, we agree with this request because the work is not mission critical or mission essential. And essential is obviously a little bit of a COVID-19 word. Most of the stay-at-home orders had used the word essential. So that was not so unexpected, but that terminology is really what folks are focused on, along with whether or not a delay or suspension is going to cause an increased impact to human health or the environment. If you talk to the regulators as well, they really are viewing these policies both on the federal and state level as regulatory flexibility rather than enforcement discretion. And what they're trying to do is they're putting a little bit more burden in their view on the regulated community themselves, environmental lawyers and companies, to be able to make the right choice at the right time. And the difference is, as we mentioned previously, at the federal level, I received pretty quick and succinct responses that we agree with delay and postponement. And initially, these were done, you'd put a request or notice into the project manager and the attorney that is operating on the site, or sometimes even just to the project manager. Now I know that the regions are viewing these very differently. So a request that was handled pretty quickly and granted pretty routinely back in March or April, you cannot expect the same thing to happen right now. I know, for example, that in Region 4, definitively, that the project managers are not allowed to grant any additional requests to postpone or suspend any on-site work without taking it up to the enforcement folks And in certain circumstances, depending on where that site is ranked in that region, it has to go all the way up to headquarters. And the idea is, at this particular point in time, they think that those requests need to be looked at much more closely, and that since things have changed, that in many circumstances work can go forward, even if with following CDC guidelines. And I know, even though all of our requests for approval were granted that we put in for our clients, I do know EPA has denied some of them. Although I'm not involved with the Portland Harbor, for example, I know there was a COVID-19 related request for an extension related to the remedial design that EPA denied at that site. Now, keep in mind that remedial designs are often desktop, not necessarily in field, although there could be a combination. And so that could have been part of the rationale. And we know for a fact as well that Ohio EPA has granted every request that has come across its desk, whether it be for on-site field work or related to facility operations, but not necessarily in their entirety. For example, one of the things Ohio EPA has said is if there was residential sampling, and normally go into the residential homes to conduct that sampling, and there was an ask to suspend that, they asked to suspend that, they responded with saying, go ahead and do some sampling in the backyard, just don't go into the homes. And so they're trying to make a holistic analysis about the need for that data and put it off where it certainly makes sense for human health and the environment. We don't know what's going to happen, though, in terms of a failure to comply, and that's what we're waiting to see. And what we're really waiting to see is when and how these folks are going to terminate these policies. So you saw that the US EPA policy is in effect until US EPA terminates it. In talking to some folks at Region 5 and Region 4, it sounds like termination can be expected in the pretty short term. Of course, if the courts don't step in first, as you heard from Tasha. But I think folks are waiting to see whether or not at this particular point, the stay-at-home orders are going to have to come back because there's an uptick in cases and states pull back again, or if it stays status quo, then I think they're likely to see terminations of the policy. And then there'll be a lot of catch-up time, of course, until we have a chance to understand exactly where all the sites stand and how things are evaluated. The other thing, just as another note before I talk about this last area, is that I also think the actual request for these extensions or suspensions or permit accommodations, as you might call them, have really decreased. Someone at Ohio EPA told us that they were receiving maybe 15 of these a day, and now they're down to maybe 2 a day. So I think that, and we're certainly making a lot fewer of them. And just this week, for example, one of our sites in Region 4 where we had delayed some work, we decided to go ahead and we're going to go ahead and do that work in the next 2 weeks. So I do think we see things evolving both on the regulated community side as well as the regulator side. And so what can we expect in sort of what people like to refer to as the new normal from the agencies here? And I hate that, just FYI. Nothing is normal about what we are doing here, so it's certainly not a new normal. But I really do feel that we are going to see things being done a little bit differently. So inspections are not happening at the federal level right now. Everyone I spoke to in all the regions said the only time they're sending inspectors out is if there is a release, and it has to be a fairly significant release. Right now, most of the regions remain work from home, and the return to the office time is scheduled for anywhere between the next 4 to 6 weeks, with some folks potentially telecommuting for longer than that. So they are really limiting the inspections. On the state level, I will tell you that some states are definitely going forward with inspections. Interestingly, we have a client with a facility in Virginia, and Virginia DEQ, on literally the first day they were back in the office, wanted to do an on-site inspection. And we're in a weird world where a lot of our clients have no visitor policies for very good reasons right now. So trying to figure out how to mesh a no visitor policy with a state that wants to conduct an inspection is interesting, although we were able to work through it. So we have lots to work through as these new changes arise. And then in talking to some of the regulators about what they see for inspections, they certainly see the use of virtual inspections and even drones. So get ready for that. And it's really hard. Ohio EPA confirmed that they are working on a policy for virtual inspections in certain circumstances. And to me, I guess on the positive side, that will certainly eliminate the surprise factor, because I do not see a situation where they could actually just show up and do a virtual inspection, right, virtually. So there's going to have to be some notification requirements. So with work from home, I think what we're seeing is more desktop items such as NOVs and information requests, and we'll likely continue to see those things. But the bottom line in sort of talking to all the folks that I was able to chat with on the state and federal level is everyone says there's just going to be a really large backup. So we're not going to really know what we have until we get back to the office and really start looking into things. And that we're likely to put things in separate piles as low, medium, and high priority in terms of enforcement, and really focus on the high priority. So to me, that sort of brought me back to the beginning of where we started in my section here, meaning that the agency is again going to end up focusing on the most high priority violations. And I think we have a big query whether or not citizen suits and things like that are going to try to fill the gap that the agency is unable to really fill, the agencies are unable to fill themselves. So with that, I'm going to hand it over to Joel, who can talk to you a little bit about how you can manage your compliance during this time. Joel?
Thank you, Heidi. So I'm going to go into a little bit more detail into the U.S. EPA policies because the states vary so much. I will focus on the federal policies. So as you've heard, the EPA policies are temporary, but they remain in effect until further notice, as are most of the states, further notice or some sort of court ruling or overruling. So I'm going to focus on best practices for managing noncompliance during the pandemic. As Heidi said, we're not seeing a whole lot of noncompliance at the facility operational level, and regions and states aren't as much as well. But that doesn't mean that that there aren't instances out there. Certainly, at the beginning of the pandemic, when there was so much uncertainty and so many restrictions, and that could happen again if there is an uptick of cases and we need to go back to where we were back in the March timeframe. So the keys to the policy, as Tasha noted, include maintaining compliance if possible and taking prescribed actions in the event your facility or business can't meet certain environmental requirements as a result of COVID-19, including documenting and potentially reporting the facts of the noncompliance to EPA or to the state agencies. So let's start by reviewing the basic requirements under the EPA enforcement discretion policy. First, EPA emphasizes that entities should seek to comply as much as possible, but if COVID-19 is preventing noncompliance, you must act responsibly under the circumstances to minimize the effects and the duration of the noncompliance. The next thing you have to do is document. If you come into a noncompliant situation, you have to document that noncompliance and potentially report that to the agency, which I'll touch upon a little bit more in a moment. But the burden is on the regulated community to identify the key information regarding the noncompliance, including the specific nature of the noncompliance, the dates when it began, how COVID-19 was the cause. That one is really one of the keys, which I'll go into a little bit more detail on. But you also have to talk about the decisions and actions that you took in response to the noncompliance, including your best efforts to comply prior to the noncompliance and the steps that you took or are taking to come back into compliance at the earliest opportunity. So we all know that this is a new policy. It's unprecedented, and therefore it's untested. But a reasonable reading of the policy, as Tasha talked about earlier, is that this is not a get-out-of-jail-free card for the regulated community. So EPA expects compliance if possible and documentation of noncompliance as to how COVID-19 caused it, and then a return to compliance as soon as possible. So my two young boys who are huge Star Wars fans will be very thrilled to see that I fit in a Star Wars reference here. as Yoda said in The Empire Strikes Back, and I do a good Yoda, but I'm not going to do it here, do or do not, there is no try. Well, that was a long time ago in a galaxy far, far away, and I'm pretty sure that Yoda and the Star Wars rebels never faced COVID-19, because EPA is now making it clear that, in fact, trying may be enough as long as you make all reasonable efforts to maintain compliance and follow the steps if you are not able to comply. What that means is you have to have a plan in place to mitigate or reduce the likelihood of noncompliance, which Devin is going to talk about in more detail in a little bit. So one important point that I want to make is that one we've addressed for many of our clients during the pandemic is that financial impacts from COVID-19 should not by themselves be the explanation for noncompliance. And what that means is, from the beginning of the pandemic, we've all felt the financial impacts of the pandemic. And unless you're in the PPE industry or the disinfectant industry or a couple of other industries that went gangbusters during the pandemic, it's likely that your business has suffered from the pandemic. But the conditions in the policy strongly suggest that EPA does not want you to consider financial and will not accept consideration of financial impacts. They're more interested in what physical barriers to compliance came about, such as an inability to perform a task without social distancing or otherwise following health protocols. So this slide summarizes some of the events that either require internal documentation or affirmative reporting to an agency. I won't go into detail on all of these, but if you'd like to read up on them in more detail, they're on pages 3 through 5 of the EPA policy. But I will say that I'll mention a couple. For internal documentation may be acceptable for noncompliance of routine monitoring and reporting. EPA lists many examples in its policy of what that means. Some of them include stack testing, fence line monitoring, tank inspections, stormwater inspections, effluent testing, and various types of training. It is important to check applicable permits and regulations and statutes, however, because EPA's policy is clear that if the if there's a noncompliance reporting obligation in one of those legal documents or laws, you must report to EPA rather than just document internally. The same goes for obligations to report noncompliance that may exist as in terms of administrative orders and consent decrees. And not surprisingly, if the EPA makes it very clear that if noncompliance leads to operations that may create an acute risk or imminent threat to human health or the environment, or failure of air emission controls or wastewater or waste treatment systems, that you must report those to the agency. And of course, EPA says that criminal violations are not subject to the discretion policy. So what should you do in terms of preparation? You should have a plan. Although we're hopefully getting close to the end of the current stay-at-home orders, we don't know if it's going to end anytime soon, and we don't know what will happen in the future. So it's important to make sure that you have personnel and other necessary resources in place to provide notice to relevant agencies, especially in the circumstances of monitoring exceedances or accidental releases or other circumstances that present acute risk or imminent threat to human health or the environment. So your plan doesn't have to be voluminous, but it should be clear. And I thought about it in terms of the 5 W's. So just covering who's responsible for doing the documentation or reporting, what must be purported, what must be provided, and when. Where should the information be provided to EPA, to a state, or can it just be recorded internally? And I would suggest having a designated location, either at your facility or elsewhere where you're separating and having this information in case you are later audited by EPA, which is certainly a possibility. And I would also say that you'd be best served by not just recording the 5 Ws for non-compliance, but for also returning to compliance. We know that EPA's resources are limited right now, but I wouldn't be surprised to see random or targeted company audits for the use of the policies, especially in light of the pressures that EPA is feeling from the various lawsuits that Tasha talked about. And also, I pulled this quote out from the policy. Just look at the language in bold, how much EPA hedges itself as to whether you will qualify for enforcement discretion. In general, the EPA does not expect to seek penalties for these various matters of noncompliance where the EPA agrees. So you might think that you have a very good case right now, but it's not guaranteed, and EPA will have the opportunity to disagree at a later time. So we've talked quite a bit about field work. I will just say that in practice, I have seen a lot of what Heidi has seen. Overall considerations include whether the field work can continue. For the most part, I've seen our clients continue with remediation activities. However, there have been instances, especially where it's not as, I don't want to say as important, but it's not as critical for a project or as protective to human health of the environment. For example, if you're just on a quarterly monitoring program and you can't perform the quarterly monitoring by following social distancing and other health requirements, the agencies have been pretty flexible to allow you to either defer that work or just skip a quarter. And again, I think Heidi mentioned it, if you're transparent and you communicate promptly with a project manager or legal counsel about the concerns you have with field work, I haven't seen any instance where the agency has tried to put our clients or our consultants into an uncomfortable position over the last couple of months. So I wanted to talk briefly about self-disclosure under US EPA's longstanding self-policing policy. The policy has been in place since the year 2000. EPA actually specifically mentions the ongoing existence of the self-policing policy in their COVID-19 enforcement discretion policy. I personally would treat noncompliance under COVID-19 the same as in any other circumstance where you evaluate the benefits and the risks of self-disclosure to EPA under the self-policing policy on a case-by-case basis. The key here is that kind of goes without saying, but you have to meet the policy conditions in order to reap the benefits of the self-policing policy. The federal policy has 9 conditions. I'm not going to go through all of them, but the two of the most important ones, they're numbered 1 and 2 in the policy, that I would highlight are discovering the violation through a systematic process, either through an environmental audit or the implementation of an environmental management system. That's the first one. So under COVID-19, you should just consider how you discovered the violation, because under the EPA self-policing policy, if you don't meet this condition, you may still be eligible for mitigation of a penalty, but it would only be 75% of the gravity portion as long as you meet the other 8 conditions. And then the second condition that I wanted to highlight is the voluntary discovery condition, which says that if you can't discover the violation as a result of a legally required monitoring, sampling, or auditing procedure. The self-policing policy gives several examples of discovery that would not be voluntary and therefore wouldn't be eligible for penalty mitigation. That includes emissions violations detected through a required continuous emissions monitor, violations of a NIPD's discharge limit, and violations discovered through a compliance audit that's required to be performed by a consent decree or a settlement agreement. So if you don't meet this condition, it would be unlikely that you would benefit from the self-policing policy. So again, the COVID-19 policy is new and untested, while the self-policing policy has been in effect for 20 years. And I would just recommend that if you find yourself in a non-compliant situation, to evaluate both policies and determine which or either the policies you might be able to benefit from. So I will end with the concept of returning to compliance. I think most or all of our clients want to comply. There are many reasons to return to compliance if you are out of compliance due to COVID-19. Of course, returning to compliance can limit potential environmental impacts. It's good for business and public relations. You don't want to be called out for noncompliance under these circumstances. And if there ends up being some sort of public disclosure, as the NGOs would like, that would be another reason to return to compliance as soon as possible. The quicker you return to compliance, the better your case would be if you receive a citizen suit notice of intent to sue. And don't forget to document that return to compliance. So I will end with that by saying that EPA does describe situations where you may need to make up a missed event when you don't, in times when you don't need to. There are nuances to that, but in general, EPA says that they don't expect facilities to catch up on missed monitoring or reporting if the underlying requirement applied to intervals of 3 months or less. But if you miss, for example, a semi-annual report or sampling, you'll likely need to make that up. But I would check with EPA before conducting that work or doing that report. So with that, I'm going to turn it over to Devin to take us home with best practices for future compliance in the event that we see prolonged or renewed closures and restrictions. Devin?
Hello. All right. Can you take me to the next slide, please? So like Joel said, I'm going to be focusing really more on the operational level of what can you do in the future. And frankly, in today's world, whatever the closure may be for, maybe it's COVID-19 or other restrictions, whether that be governmental or self-imposed restrictions in the future for individual companies. The first slide here, and I'm going to try to go through this quickly so that we have time for questions at the end. I'm going to follow rarely the advice of my 20-year-old nephew and encourage everyone to be an early adopter of technology here, because really all the recommendations for this forced integration of technology into your meeting your compliance obligations, I mean, they've been around for a while, and I see a lot of clients that have maybe resistant to implementing them in the past, and now may be the right time to move forward with it. The first one here, electronic forms. I mean, this is somewhat self-evident, but there's still quite a few manufacturing clients that we work with that are very reliant on paper forms. And when you have a situation where part of your workforce has been furloughed, for instance, perhaps your EHS compliance manager is working from home, and then you have your facility folks that are continuing to work at the facility level, you could have different forms being used by different people, consistency issues being created between facilities, and access issues, as you have one person at the facility filling something out and another person at home ultimately being the one that has more of the reporting obligation. So focusing now on creating electronic forms can help to alleviate those kind of consistency and access issues. The next one I mentioned here, and this is just these are just examples, there's many more. The e-manifest system. For those of you that are hazardous waste generators, you're familiar, obviously, with the need for manifest for any sort of hazardous waste that you're sending off-site. Now, historically, this has always been a paper system. Back in 2018, however, EPA did roll out their e-manifest system, which provides a platform for electronic signatures, more real-time access. If there's an issue with waste being accepted at a particular facility. So it has even more value in the current environment where you might be dealing with closures, restrictions, et cetera, in the future, to perhaps invest in that sort of shift to the e-manifest system now, which could help, again, in that situation where you have your EHS manager perhaps working from home, that needs to fill out that biennial report or the annual report and doesn't have access to manifest and other RCRA documentation back at the facility. So it would be a good time to force that transition. The next one here is online training options, which surprisingly is actually one of the biggest issues that I encountered during the current pandemic circumstances, where a client had regular training obligations for their staff, whether that be for air compliance or RCRA compliance or whatever it may be. And sometimes those are annual requirements, sometimes they're even more frequent. And when facilities started being closed and or employees were required to work from home, all of a sudden they were afraid that they weren't meeting their training obligations. Now, this was before all those policies came out that have been gone over today. But investing now and doing some research into what sort of online training options are out there, which there are quite a few, would be a prudent investment at this point, whether that be something that you're going to or are able to train your employees on in a virtual environment. It's something to kind of map out, see whether or not you have the resources to be able to do that in-house now to avoid that potential compliance situation. The next one is audit software. This has been another, sorry, Joel, can you go back? Audit softwares, audits have been a victim of the COVID pandemic for, I think, most of our clients, where either for financial reasons or staffing reasons or visitor limitations, normal EHS audits have not been able to move forward. Well, a lot of facilities are already working with audit software and audit protocols. They're very common on the marketplace. But implementation of some of those protocols in-house where that's possible, or investment in the protocol itself, would allow facilities to potentially be able to pursue audits in the future in the event that restrictions are occurring without having to potentially deal with those financial limitations, staffing limitations, or visitor limitations, which would help you again to address the issues that Joel mentioned on voluntary disclosure policies and things like that. The next one here is use and access to compliance documentation. This is another big one, and it's really related more to the electronic forms aspect that I mentioned previously. A lot of clients right now, where they are working from home, they may not have access to their permits, to their administrative orders, or to particular documents. And most clients these days actually have pretty robust extranet software or other kind of secure technology. But the reoccurring theme that we see is that those aren't actually populated, because admittedly, just like my own filing, you don't necessarily want to spend your time to put all this stuff online. Well, right now is the opportune time to be building a more robust online compliance workspace, I'll say. And some of those can be provided, of course, in-house. Sometimes your attorneys or your consultants can provide these sorts of systems. But it is a good thing to be investing in now to avoid situations where, not only for the convenience internally, but in the event that you do get an information request or a regulatory inquiry, to be able to answer that promptly, it many times helps to avoid an enforcement situation. And the last one is investing in technology now to facilitate inspections. Some of our higher, more sophisticated clients will invest in things like iPads and other types of software that would allow for real-time access basically to inspection materials or inspection documentation, photos, etc. Things like that are going to be important in the event that there's additional closures down the road. Next slide, please. So I think all of that gets baked into what really I'd call more of your COVID-19 compliance contingency plan. And frankly, most folks have facility closure plans, but I think it's a good time to revisit those closure plans, because the current circumstances have led to more widespread closures, situations, again, where some employees are on staff, some employees are off-site, some situations where one facility may be closed, but other facilities continue to operate. So it's become a more complex situation than many closure plans currently contemplate. And so when you're considering that sort of closure plan over this summer, perhaps as you get ready for this potential second wave in the fall, these are some key things that I think you should consider in such a plan. The first one here, waste disposal and recycling locations. And for all of these, I think you have to consider, how material is the impact if it's disrupted. Some of these is not a huge impact, but if it's a really material impact that completely disrupts your operations, it's going to be something you want to address now. So an example of the waste disposal and recycling locations, this actually was pre-pandemic. If you go back to the trade war that's been started against China, there's a lot of electronic recycling that goes on in China. And when that was disrupted, it actually led to liability for a lot of our clients where that waste stream was being redirected to other facilities in the U.S. and or had to be kept on site, which created potential liability. So if you have a significant waste stream that you are right now managing in a way that would, for instance, require it to be sent overseas or require it to be sent to a state that you know is going to have a more restrictive closure obligation, then that might be something that you want to consider or earmark in your contingency plan to say, these are things that we should be considering alternative options for now, so as to not disrupt our operations from continuing to proceed. The next one is identifying expiring permits and mapping your permit compliance obligations. For instance, if you have an important permit, a Title V permit or something else at one of your facilities that's set to expire this fall, it might be a good idea now to be talking to your regulators on getting the process started for renewing material permits for your operations. So you're not left in a lurch where the regulators may no longer be in their offices, but you are an essential business allowed to continue to operate. You'd want to know that now and identify those at-risk permits. Along the same vein, mapping your permit compliance obligations, I certainly don't mean that you need to recreate your entire permit, but for instance, we have a client that has a wastewater treatment plant on site, and that wastewater treatment plant requires notifications to regulators in that particular state if their operations are reduced to a point where it's going to impact their discharge. So that's one aspect. But then there's also compliance obligations where sampling has to be averaged over time. So if you're talking about a multi-facility campus or something along those lines, and one building is being shut down for financial or regulatory reasons, then you're going to want to know what sort of permit triggers are going to be triggered in that situation so you're not scrambling come a closure, and you'll know in advance what sort of proactive measures you might need to take. Let me just skip down through a couple of these in the interest of time. The last one is probably the most practical, but it comes up the most often: staffing availability. We're in this situation right now where you have so many furloughs of staff. What I find often is the individual that we might need to fulfill a compliance obligation or that has that training to do the certification under a particular regulatory structure is no longer available and can't be accessed. So identifying those key individuals that are important for you to be able to fulfill your compliance obligations, putting that into your contingency plan helps to, again, identify those key issues so that you always are not scrambling in the event there is an additional closure. Next slide. And we're actually rounding out at the end of the hour here, so I'm just going to summarize these last two slides so that we have time for questions. The last two slides essentially go into what we've been talking about all along. Is enforcement a possibility? Absolutely it is. I think you can foresee potential new technologies being used to inspect facilities, and all of what I just talked about are ultimately those proactive measures that you should be putting in place now, which could ultimately be the tools that you would need to address, whether that be an enforcement action, inspection, information request, or a citizen suit coming at the end of a particular closure period. So, Joel, I think I'll kick it back to you now and open this up for questions.
So I think, thanks, Devin. And I think we only have a couple minutes left. I want to be really respectful of everyone's time and give you the CLE information. I'll quickly throw out an answer to one of the questions we received, which is whether or not any of the states or regions have talked about a plan in case there's an uptick in cases at the end of the year and more stay-at-home orders. And I will tell you, I'm not sure anyone has a specific plan at the moment, but I do know that they're talking. For example, all of the states within Region 5 are having very, very regular conversations, and they're having the same conversations that we're probably all having, right? How can we do things without physically being somewhere? And I've already talked a little bit about the virtual inspections and the like. And I know that they are being very strategic in thinking about how they can do some of the things like scan in their mail when they get an NOI about a citizen suit and things like that they didn't do previously. So they also are a lot less paper heavy and reliant on that. So I would say they're making some general plans. I think right now the only discussions that have been more definitive is if the stay-at-home orders actually go into place and the policies had been terminated previously, that they would think about whether or not they would put those in place again. So I don't think we have much more time for questions, and I want to let everyone know if you're seeking CLE for today's program, the tracking code is TH0609. Again, the code is TH0609. Of course, if you have additional questions after today's webinar, please do not be shy. Feel free to email or call your current Thompson Hine lawyer, who will direct you to a member of the COVID-19 task force or to one of us. If you are not a current Thompson Hine client, please contact one of us and we will discuss with you options to address your needs. Also, if you are not currently receiving our updates or invitations, we invite you to go to the Thompson Hine website and register to receive our mailings under the Publications tab. We really thank you for your interest in attending today's webinar. And one more time, the tracking code for today for the CLE is TH0609. Thank you all very much and enjoy the rest of your day and stay well.